hello and welcome to all the attendees and to the quick presentation sponsored by Femeda.us. The speaker for this particular session is Dmitri Dubograev, founder, managing partner, and CEO, Femeda.us. The topic of this session is 5 Cardinal IP sins committed by startups. So, Dmitri, if you would like to take it forward.
Okay. First of all, thank you very much for the invitation to this wonderful and fun event.
It is a pleasure.
And you should be able to see my slides now. 1 second. So basically, a few words about our firm. We are a small boutique firm that focuses on IT and corporate representation of small clients, particularly the ones that are entering Western markets of Western Europe and United States. So we represent over 300 clients. Most of them are internet-based or application-based. So basically, the sins that we have seen in our practice represent not necessarily high-level legal theories, but rather day-to-day operations that could be useful to both practitioners and to small businesses. And I know these sessions that we've seen today are focused on a lot of legal minutiae and details. I want to bring people a little bit down back to earth to actually maybe observe those shortcomings and those bottlenecks that faced by small companies. So basically, as Marcus Aurelius said, make your challenges into your advantages, and when you see an obstacle, the obstacle becomes the way. So what we see in the operations of our clients is they stumble upon their own intellectual properties. So what the first sin that we observe is basically failure to organize as an entity, as a project. Even though maybe it's not related directly to intellectual property, but a lot of developers or designers or businessmen do not think about the fact that when they start a project, they need to basically have a set of mind that the entire operations, particularly in today's world, is intellectual property. So we saw numerous occasions when somebody would come to us and say, "Oh, we don't have any IP," which is a pretty outrageous statement for anybody that practices intellectual property and corporate law. However, that's a prevalent shortcoming for small businesses. So basically, right now we should understand that right now it's not really economic war, but rather the war of IPs. A lot of technologies, applications, websites, services are easy to replicate. So essentially, it becomes a fight between who owns the right to certain intellectual property, images, trademarks, and so forth. And what we suggest to smaller businesses and entrepreneurs is educate themselves about the IP, and obviously copyright, trademark, patents, trade secrets, and what I consider a new type of intellectual property is basically privacy, client list, and personal identifiable information, and so forth. So basically, this is the actual photograph of me offering a solution to the client. And so basically, jokingly speaking, but at the same time, it's an approach that many businesses, unfortunately, are guided by when they ignore a long-term solution in lieu of a small-term saving and immediate results. So we basically implore our clients to think about the IP strategy and attitude. So basically, second sin is the structure or basically no structure at all. what people should realize is that their IP should be held in a good vessel, meaning that the first line of defense is IP protection is a good in basically corporate structure, whether it's individual entrepreneurship, company, corporation, and typically in a jurisdiction with favorable and best protection of intellectual property rights. So basically, one of the choices of jurisdictions, make sure you have fair and quick courts and arbitration. In fact, in Virginia, where we are located, for instance, we have a statue of the rabbit and the turtle from the famous fable, and it says, "Justice delayed, justice denied." So our courts are, for instance, are considered the fastest in the United States, with a typical timeline of 9 months. So enforceable contracts, clear rules of the games among the founders and owners of IP. We've seen maybe at least half of the failures of the projects caused by the fact that the founders essentially have squabbles amongst themselves, not being able to enter into a good contract and prepare for the next stages. In center of management of IP, so sometimes developers or inventors would basically act in consortium rather than in the company, rather than act individually and have arguments about the management. So can you see the slide, third sin? So basically, the third sin is the failure of copyright, meaning that, first of all, what's a copyright? Copyright is anything that you originally created in a tangible form with a minimum level of creativity. And a lot of, again, inventors or project entrepreneurs don't recognize things that of their creation are subject to copyright. And anything that they create themselves or anything they order as a work for hire to the employees or contractors must be a work for hire, meaning that anything and all copyrights created fall into the domain and realm of the project. So it has to be a focused aggregation of the ownership. And basically, anything that anybody wrote as a copyrighted materials, it always somebody's. So we've seen numerous instances when programmer would take somebody else's code or picture and say, well, I found a picture on the internet and I copied it. And then you basically find copyright or patent trolls that do cease and desist letters or even file a lawsuit for copyright infringement. So you have to educate yourself, educate your employees that it's not really public, it's somebody's, unless it specifically says otherwise. So, and make sure that when you use open source, you still get a license. Again, it's somebody's, it's not a free-for-all. And you should try to register copyright because it gives you a much more leverage from the point of view of being able to recover legal fees. You can get either basically statutory damages, which is up to $150,000 per violation, or at the same time have just a quicker response for infringers. If, for instance, you have somebody that copies your software or copyrights your other production, the DMCA notices to Google and to Apple work so much faster if you actually have a registered copyright to your work. So the fourth sin is ignoring your TM. First of all, you must be able, can you see my fourth slide? On the top it says fourth. So basically, the fourth is mess or just a bad situation with trademarks. In essence, when you act as a business, you conduct your business under a certain trade name, which is called a trademark. And people sometimes do not choose good names. We had clients that asked us without having maybe a proper knowledge of improper English, they were using shortened names for their business, and somebody wanted to call their business BS software, and they thought BS stand for software, and obviously in the daily world BS is associated with something else, and it's not the way you want to name your business. We also had some businesses that unfortunately had tacit references to sexually transmitted diseases. So when you choose your name, particularly in not your native language, you must be aware of these pitfalls. And then obviously you have to do the trademark that sounds good, has language appropriate for CMM purposes, but also you have to choose it legally. What it means is it has to be non-descriptive. You can't sell beer and call it beer. You can't sell basically search optimization services and call it best search optimization services. Basically, the law does not let you monopolize descriptive words. So no conflicts with other marks. So you can't really start, a business that would be called Google, even if you spell differently, or if you basically produce computers or devices and call it Apple. So conflict check must be conducted before you spend money promoting your business and building a trademark. So you have to register your trademark in your main markets. Again, it gives you a leg up in negotiations of settlement for infringement, gives you treble damages, it gives you an opportunity to sue in federal courts, which in the US are considered a higher level judicial forum. And obviously, registration of trademarks is something that accumulates your value, your property. The fifth cardinal sin in the IP, and I'm sorry if I skip patents. Patents are important, but I think in a lot of stages, on early stages, patents are not something that is not affordable to the clients. And I think it's important to do if you have the money, but if not, there are other ways to protect your business. And you should obviously focus on a patent with true inventions and novelties. So the fifth sin generally is squandering your IP. And so basically, when people have intellectual property, they squander it without having a tight, bulletproof contracts when somebody uses your IP. So we've seen so many contracts that are not terminable, forever. There's a contract recently I've seen that the license has been given for 70 years, which is not the way to conduct business, because the environment changes, your financial situation changes, and you want to be able to have some leverage as to how to basically handle your property. You have to be able to terminate for breach. So if whatever agreement you have, it has to be consequences for breach. We've seen so many contracts that are poorly written that have no termination, and not termination even for breach. So even if somebody stole your source code or other important property, sometimes it's been inconsequential for the violator. You have to have the confidentiality within the agreement for both parties. So even if you share financial statements, it has to come with obligations of non-disclosure. And all licenses always have to be limited. And if you are conducting a business with exclusive license, such as license in the territory, so the formula there would be time, KPI, some KPI, basically milestone, and market. So if somebody comes to you and says, listen, I'll be exclusive distributor on this market, it has to come with at a certain price, time, performance, and market. And basically, the last of the aspect of squandering your IP is something that, despite saying, defund the police, you have to police your own trademark. So refund your police forces for purposes of conducting and managing your IP and seeing that your IP is properly used. For instance, one of the shortfalls is so-called naked license. Is basically you give somebody a trademark to produce your goods, but you don't control the quality of the goods being produced, which automatically puts you your trademark into the category of basically naked license, and you lose it. So what do you lose if you commit those sins? I mean, road to heaven or IP heaven, yes. But at the same time, rights to property, you could lose technology. Somebody else uses your source code. Exclusive use, so someone else uses your stuff. So you use it or you're supposed to use it. And remember, intellectual property is not necessarily similar to you owning a car. It's ownership of intellectual property is something more important, is to exclude others from using your intellectual property. And so when you don't have exclusive use of your own IP, somebody else may use it with impunity. That diminishes and dilutes your property. So you could lose your reputation, you could lose your time, money, and what I call it losing success. So meaning that you have success or your project has a success, but it no longer belongs to you. So somebody else is reaping the fruits of your harvest. And so a little cartoon of the wishful thinking to all the people that develop in their projects. So no matter how you look right now, with a little bit of help, you could become a unicorn. And I appreciate your feedback, questions, and this is our contact information in case you need to contact us. Thank you very much for your attention.
Thank you, Dmitri, for such a wonderful presentation and sharing your knowledge about the sins not to be committed. And we have a question from Chike. Why do you need a license for open source? Please clarify.
So remember that open source, and so there are copyleft, copyrights. Basically, you could see that the copy open source, sometimes we call it a hippie code, right? So basically, sometimes, most of the time, the open source is still a licensed code. So you will see different types of license, whether MIT type license, GPL, LGPL, and even though it's readily accessible, you basically, when you start using that code, you accept the license that has been provided to you by the original author. And sometimes these open source, you will have certain limitations. You can't use it for commercial use, or if you use it, then you must, if you use open source code, then you must publish source code of any derivative work. So what happens sometimes is that you take open source, so you think it's readily available, so you can take it, incorporate it into your proprietary software. And when you incorporate your proprietary software, actually the open source license, GPL for instance, forces you to publish your code for derivative work. So what we do sometimes is when we have an open source license, we try to separate in the product anything we do derivative, because we might be forced to then publish source code and proprietary. But you have to be able to separate within the project, even within the software, files and executable, basically, and the libraries, in order to make sure that the poisoned code, poisoned by the open source licenses, does not infect your proprietary code. And we do a lot of commercial transactions for financing and the sale. and open source is always a big sin done by developers that essentially think that anything that is available, without hacking, is also usable in any way you want. So when you use a source code, make sure that you understand the consequences of the specific license that you, by your actions, adhere to. And I hope this is basically clarifies my statement as to quote unquote need a license. Need a license means you agree to a certain license, to certain terms when you take something. So it's the license by your action to use the code. I hope that's an answer to your question.
So I hope, Chike, you've got your answer. And thank you, Dmitri, for such a lovely presentation. And I would also like to thank Femeda.us for being the reception banner sponsor for this IPR Gorilla. So we have a comment from Chike. Yes, very helpful, and thanks.
Okay, and I appreciate the ability to and the opportunity to make the presentation and be part of such a wonderful community.
Thank you so much, Dmitri.